recording, so yeah. Okay. We have with us also Juan Antonio. Good evening.
Hi, good evening. Pleasure to be here. It's my second year, but it's always good to participate. So I I think working as I started my career as a private practitioner working in law firms, mainly in the Iberian market, doing corporate M&A, but for many years already focused on the life sciences space. And then since 2015, when I made the in-house move, I've been working as an in-house lawyer. So starting with some genetics companies, and then in 2019, I relocated in Switzerland, where I have my current role. So I work in a joint venture. It's a joint venture between a medtech, Fresenius Medical Care, and they run all this, produce the machines for dialysis, and they run all the clinics. And CSL Group is a company. We have different business units. They have plasma, they have other drugs, but nephrology is where we are really focused on. So yeah, so my day to day has to do a lot with M&A, corporate, in licensing, and yeah, I've been advising on many transactions in the healthcare space. I'm glad to be of help. Yeah.
Yeah, thank you. Thank you so much again for being with us tonight. So, what are we going to do today? So, there were some changes, reorganization in our cohort. We have new groups and new group presidents. If you haven't selected your new group president, that should be done this week and announced before the go-to-market session. So, you should send us an email and announce a new president, and of course organize the working group meetings. So these are new groups: Chameleon, Champions, and Blasters. And of course, the update for our founders before we go to the mentor presentation. So from now on until the next review, your hot seats or your pitches are 3-minute pitches with a pitch deck. So you will be scored based on that 3-minute pitch with the pitch deck. So that will happen from the next session. First in line for a pitch will be the founders who were sent the epic sprint, so who finalized their epic sprint. So they still need to pitch in front of the mentors, and that will happen during our next session. Also, you already received the email. So for those of you who already do not have the legal entity, you should start, and go towards the founding legal entity. So you received instructions, and if you have any specific questions regarding that, you can book office hours with Ned, George, or myself to discuss further about it. Also, all the questions regarding warrant that needs to be signed with FI is something that you should discuss with Ned, myself, or George. So you can book office hours for that. So today's session is not about the warrant or legal documentation regarding FI. It's more general and also more for specific questions regarding your business currently, the issues that you're having, questions you want to ask, some things that you want to clear out. Okay, so now we will go to mentors presentations. Anya, would you like to be the first one?
Of course. If I can just share my screen, just a second.
Mm-hmm.
Just let me know if you can see the screen.
Yep, we can see it.
Okay, perfect. So our presentation for the day is called Legal Do's and Don'ts Startup Edition. It will focus mostly on how startups are incorporated, what are their legal forms. It's going to be talking about legal due diligence process from the perspective of the investor, but also otherwise. It's going to be talking about intellectual property, which is probably the most important legal part of any startup's assets. And then it's going to be talking about why it's important to stay compliant. So when talking about, before we begin with the due diligence process, we just wanted to cover first some of the main ways that a startup can be incorporated. That is something that most founders don't think about at the beginning because, of course, they're focused on the product and focused on how they're going to be presenting their product and escalating the business and everything. But it's important to note that essentially, well, at least in Serbia, there are four legal ways to incorporate the company or to operate at all. It's essentially in the form of an LLC. It is in the form of a joint stock company and also in the form as an entrepreneur. And another form, which we won't be covering now, but for these three forms, it's important to note that entrepreneurs, when they operate essentially in a way that their whole assets are up for everything, for grabs. That means that you will be personally liable for everything that happens to the business, which is something that we do not usually recommend for startups. When talking about how a startup should be incorporated, we usually say that it's best to incorporate an LLC. This is because LLCs cover your liability. They're essentially liable with their assets or the company's assets, and the founder won't be liable personally. When talking about due diligence, there are three main due diligence processes that can be conducted. The first is legal. The legal due diligence process is essentially, you can consider it as sort of a blood test of the company. So you check, how the company is incorporated, whether the founders have a shareholders agreement, which is really important for in establishing personal relationships between the founders, and how the company is going to be essentially sold, if it's going to be sold, if a founder can exit, in which ways, etc., etc. Whether the share capital has been paid in, whether the IP that the company is using is your own, whether the employees have, employee contracts, etc. And this is important because, of course, staying compliant is always important, but legal compliance in that sense will help protect the startup, the company, not only from legal risks, but also ensure that when investors are coming in, they're seeing a completely clean slate, a completely legal operation, and it will be easier for them to invest. When talking about the financial due diligence will depend on whether the company or the startup has revenue or not. But in essence, it will mostly be focusing on business viability and some forward-looking assumptions and forecasting assumptions and cash flow positions. It will be looking at historical financial statements, even if the company has any, or any audits, also if it has any, and existing debts, obligations, liens, whether there are any convertible instruments, whether the founders already issued some safes, or, well, which in Serbia is not really possible, but if you issued shares for somebody, investors always want to know that before coming in the company and investing and they want to see that you have revenue sources and predictability in that sense. Then technical DD, that's something that's conducted if you have a technical solution. They're going to be checking if you're using open sources, if you have a technical solution, how you came to that technical solution, the architecture and code quality, use of any third party dependencies, whether you have licenses for such use, etc. Then intellectual property is something that is the core, should be the legal core of any startup. In essence, here we're talking about copyrights and trademarks, but also patents, of course, if you have a technical solution of any sort. But copyrights and trademarks are important for any tech or IT or AI startup, if you want to call them that these days, because copyrights essentially protect startups from other companies using their brands, their logos, anything related to that company, anything that potential investors or your potential business partners or third parties will be connecting with your product. And that's something that we always recommend is done in advance and as a first step towards complete legal compliance, because copyrights are they're not that cheap and not that complicated to implement and can really protect the business and its scalability. Then trademarks, Oh, sorry, that was the that was the trademarks part. So trademarks are what protects the brands and the identity. Copyrights are essentially, the software, the legal code, everything that you have in that sense are copyrights. If you think about it, copyrights do not protect the substance; they more protect the form. So if you think of a novel, you wouldn't be protecting the idea behind the novel. You would essentially be protecting what is written and that other people cannot copy paste your work. It's the same with softwares. If you have a code, people cannot copy paste your code and use it and then apply their brand and logo and essentially, pretend to be you. That's what that's for. The difference between the two is that trademarks, have to be registered and copyrights do not. So software, once created, is the property of the person who created it, which is really important when you have a startup because a lot of people don't have employee agreements and they don't have the agreements that regulate the copyrights for the software code. But that's, well, at least for Serbia, really important because if you have a person, a third party dependent who's working for you, and they, prepare a software and create the software for you, and you think, okay, that's mine, that's the startup's. It really isn't. It's the person who created it. That's their own They have copyrights over the software. And something that's also important is to know that you can always, essentially storage the software, the code, with the Serbian IPO office, and that protects you in any sort of legal dispute that you have. A certain date when you storage the software and it's there, and you can, easier. It's going to be easier for you to prove that the software is your own. So relationships with founders, employees, and other engaged persons are something to really consider. Always have agreements, always have NDAs, always, make sure that the intellectual property is transferred to the company, to the startup, and that you can be protected later on in case of any disputes. Why it's important to stay compliant? I mean, it's sort of obvious, but you don't want to run into any legal issues. But it also has, it's going to be easier for any serious investor to invest. They always look at your books. They always look at the legal status, the relationship between the founders, and it's not only the idea, it's not only the product, but it usually also really, really depends on how the whole structure is of the company and how legally safe it is to invest and, to stay there for a certain period of time. Internal relationships and rules are really important between the founders. Shareholder agreements should always be in place. You should always regulate, even if you're really good friends with somebody and, start a business and create a startup and develop the product. You never know what's going to happen in 5, 10, 15 years. You never know what's going to happen when an investor comes, when money starts flowing in. That's something that's always good to consider. Think ahead and stay compliant. And when talking about compliant, also something that startups usually overlook is GDPR issues. So in a sense, if you have any sort of personal data that the company or you are gathering, be it that you have a company in Serbia that's offering services for EU citizens, that can also be considered as only, providing your products in English and or in French to people in France. Even though nobody's purchasing from France, you're still sort of targeting French people, and then the GDPR rules will apply. Those rules can be really tricky because the fines are really high. So it's always good to, if you're, gathering any sort of information from potential customers in the EU, but also in Serbia, because Serbian rules regarding the data protection are pretty much the same as GDPR. It only depends that, fines are not that high, but make sure that you consult a legal professional before doing, placing your products on the market and gathering any sort of personal data, because of the fines that are easily overlooked but can be really, really high. And
Sorry,
that
a
is it.
question.
Yeah, of course.
A question. Is there another slide? Because you are on the first one. I mean, we were following all that you said, just asking if maybe.
Did do you not see me changing the slides?
No, I
No.
had the same problem when I was presenting, so the people could see only the first one.
Okay, I'm sorry. Can I fix that somehow? Let me see.
Can you click on the left on the second slide? I mean, it was nicely
I'm
structured
seeing.
and yeah.
Yeah,
And you
sorry.
presented nicely, so we caught all the sections. Just
No,
wondering if
sorry. I
maybe you
thought that
want.
let me see. I thought that the slides they were moving with me, so I thought you can see them. Sorry. Let's see.
As I said, it was nicely presented, so it's cool.
Happens to the best of
I mean, you know, you missed all the really nice pictures. Can you see it now?
Yeah, really nice icons.
Really
Legal
nice.
financial.
No, it's there's only 5 slides, so you didn't miss anything that important, but I can send you the presentation if that's easier, and then you can you have my email here at least now. You can see it and you can send me any sort of questions that you may have afterwards after seeing this beautiful, beautiful presentation.
Thank you, Anya. I mean, we have questions. At least me.
So Anya, are you in a mood for some questions now, or do you want to maybe to wait after the other mentor is finished and then to have during the Q&A session all the questions?
We can have them during the Q&A so people can, you know, gather some thoughts.
Okay. So guys, because you already put in during your one of the assignments was to list questions regarding specific questions regarding your business and other legal issues that you have or equity related questions. So other questions that you have for our mentors today, you can ask them during that last part of the Q&A. Okay. Let's go further. Okay, Juan Antonio, are you ready?
Yeah, I can share the screen. Let me know if you see the slides. Can you see it?
No, yes. The fourth one.
Yeah. Okay, so now you can see the first one,
The
some legal
second one.
tips. Okay. So, I mean, to what extent there will be a kind of overlapping, at least in this introduction to what has been explained, but I think it's worth to give some legal tips as a starting. So first of all, I think that founders, they try not to engage with lawyers in the beginning, but I really encourage you that you need to get in touch with the lawyers, and you have to be creative here. So there's no need that you go to a big law firm from the very beginning. So it's more and someone that can help you in these early stages. And as you evolve, the company grows, you can go to a full service legal firm. Obviously, the lawyers, we are flexible, or the private practitioners are flexible in terms of the legal fees. So you can agree on a basket, you can agree on a blended rate. You can agree on a cap. So don't be afraid, because nowadays there's a lot of competition. So I'm sure you can find a good deal with the lawyer. So that's the first thing. Second one, and that's I can bring here an example is I recall many years ago when I was in the private practice, there was a founder that they needed to create incorporate a company, and the requirement of the minimum capital at that stage in Spain was, I think it was in the range of 3,000 euros. So he didn't have the 3,000 euros, but there was an option to contribute in kind to the company. So what he did, he just put a nice road bike into the company as the contribution, and then they register in the commercial registry. So that's an example of things you can do. So I mean, there's always a way, okay, if there's a will. Obviously, for me, it's really about mapping the risk. So it's worth that you have this legal mindset and understand. So what are the risks that I will be facing in my project, and how can I protect the assets? For me, that's a legal approach. Obviously, it's been mentioned here, and for me, this is clear. Must is already so incorporate a company. There are different ways, but this for tax reasons, and obviously in order to control, to put a firewall on the liability. So that's a must. Already has been mentioned. So the importance of the IP to identify, to assign those contracts to the company. again, proper written agreements, because in the beginning, when you are in love, with this the honeymoon, with the other partners, so no one cares about putting things in written, but this is really important. So have the rights, so have the right agreements, not everything, but at least the main agreements. You need to have in written. It's not just about verbal agreements or shaking hands. I strongly recommend to have things clear and on paper. And then the last piece of advice I would say is you need to understand, so what is the industry that you are working, or you will be working, or you will be launching your project, and what are the main regulatory things going on. And I can give you also an example. So when I was working as a private practitioner, so we had a founder that he came with a nice idea on telemedicine, okay? So it was a portal for telemedicine where so that there were different doctors from different jurisdictions that could join, and patients from different jurisdictions, but they didn't really make the mapping of what are the regulatory requirements, to provide medicine advice. So the whole business case was wrong. That's what I mean. And so I think that's, if you are operating or you are intending to operate in a regulated market, and that's obviously the life sciences one, make sure you have a clear understanding of what are the main rules, otherwise the business case will not work. So it's already been mentioned about the shareholders agreement. So the shareholders agreement is a contract, signed by the founders, and obviously, so if there are additional investors, they need to sign. And really, is a document that with the time that will evolve. So I think it's important that you sign this in the very beginning when you are, as I said, in love with the partner, and everything is positive. Because when the things go south, it's if you don't have a clear understanding of the main topics, there's likelihood that there will be some fights and some controversies there. So it's a document that will evolve, and what I have just placed here in these two slides is where some of the essential clauses, obviously these are not elaborated, but things you need to think about. This is like a brainstorming, it's a checklist for brainstorming. So the first one for me is to align on the vision. So how do you see your project? This is something that is a short term, it's a long term, it's going to be local, it's going to be international. So what do you want to go? So if you are not aligned with the vision, I think that you will face some hurdles in the way. So second, so how big is your piece? At the end of the day, different partners can make different kind of contributions. It could be cash, so you can be, bring net worth, or you can bring some knowledge. So, but in the end, everything you can put a number to this. So it's not every single partner needs to contribute with the same, but at least you need to have an understanding. So what's the stake of everyone, and I would not go for a 50% because maybe it's not the fair one at that point in time. Capital contributions. So again, so what is which of the partner, what is contributing, and more important, so how are we financing? So are you going to go with additional contribution by the partners? Will you go with a third party? There will be loans. Clear understanding how you want to finance this. I mean, again, I had an example of a startup, and there was not alignment by the partners on what to do with the profits when they came. So one of the partners, he wanted to buy houses and cars. The other one was more reinvesting, opening new markets. So if you are not aligned here, there will be again an issue. As the company grows, obviously you don't need to have a board from the very beginning. So there could be a couple of managing directors, or you can have just one director. But in the end, if there is a board, so you need to decide how to appoint the board members, how to remove them. So what are the key questions that relate to the life of the company that are reserved? So if you want to make a raise capital, if you want to merge, or if you want to open new affiliates, these type of things. So you need to decide what those matters have. Obviously, there's an allocation by the corporate law, some things that need to be decided by the shareholders, other needs to be decided by the board. but you can also state different quota and decide, okay, so this is a reserve matter, this is super important, so we want to have or make sure that everyone is aligned. But that's like a sub list of things that you need to include as reserve matters. Share transfers. So what are you going to do? So you want to keep or lock the founders for a while, or is this free? They can sell to anyone, or there will be like a first right of refusal for the other shareholders. Think about how do you share the transfers, or even if one of the shareholders is dead, so will that go to the family, or that's something that the rest of the shareholders founders need or have the right to acquire? So anti-dilution. So if you're thinking in raising capital with additional financing rounds, so that's the way to make sure that the initial founders have at least the right to keep the same quota and go for this capital raise. Vesting and lever provisions. So you all know, so the standard 4 vesting years with the 1 year cliff. So meaning that in the first year, you're not getting any shares, and this is as of the next 36 months, you get them on a monthly basis. But obviously there's something in the middle ground, so not all the members or not all the shareholders need to have the same vesting, but that's something you also need to think about. And the same with the lever provisions. What is important is when someone is leaving, to make a difference if this is a good lever or is a bad lever. So is this person leaving, because there was an illness, is because he's been expelled, or is this because he really wants to go and start a new project? So how is this regulated, and what the lever is getting, depending on if this is a bad lever or a good lever, that's also important. And moving to the last one, some other topics to consider. So in terms of governance and roles, so what is the role that each of the founders has? How is this compensated? So what are the voting rights? Deadlock. So that means that for what we said, the reserve matters, so important things that you are not able to move forward, or you are not, it's in a tight. Those you need to find a solution for this deadlock. So how you work this out, and just to avoid that the company and the governance of the company is paralyzed. Obviously, you have protection clauses, so the non-compete, the non-solicitation, in order to protect the company if any founders would like to leave and compete with the company, or even during or after, or also poach and get some of the customers of the company, or get some of the key employees of the company. So that's for this, the non-compete and the non-solicitation. Information rights is more for the minority. So once the company has grown, and also for the investors, no? So what's the level of information you're providing them? Again, so exit and liquidity. So these are typical clauses that they are tried to be included. So the drag along means that if one of the biggest or the majority shareholders wants to sell the shares to a third party, so the minorities are kind of squeezed out and they need to sell. Whereas the tag along means that there is a third party willing to buy the company, so the minorities can also join this offer. Liquidation preference, meaning that, so what is the order, and that the shareholders, and in particular the initial founders, will be paid out. So to protect that they get, in certain events, they get paid first upfront, yeah. And then, so the other common provisions that you might find is the lockup period. So these are essentially temporary restrictions where you cannot sell the shares, and the equity incentive plans, but that should be a different and completely chapter. So in essence, I think it's worth that you think about, you take this, and once you start, you have some partners, you think about all these topics, and I mean, maybe some of them are not applicable at these stages, but at least the essential one, that you have a clear view on what would you like to have in written. And it's really my piece of advice, because if you don't do it in the beginning, because you are super in a hurry and you believe that the relation is super good with your partners, in the future will be able to address these topics. And that's something for sure that when a third investor comes, would like to see, he would like definitely to see that there is a right shareholders agreement with the right governance, and all those things with clear rules.
Okay, great. So now is the time for a Q&A. So as I said, you had the assignment to prepare a list of specific in-depth legal questions to ask during this session. And if you have specific questions for your startup, you're welcome to ask them. So now we can start. Do you want maybe to raise hands? Not for me to read question by question. So I think that George already started with writing questions in the chat. So if you started, can you read the questions, George?
Yeah, for sure. Thanks for the space. Hi, Anya. Hi, Fernandez, right? If I read it properly. I'm George Obradovic. I'm founder of Includify. We are enabling IT software companies build accessible websites and apps. It's an interesting topic, actually, since you are from legal in background. All this legislation about digital accessibility in USA, in EU, we can talk as a follow-up. Now on the questions, yes, safes. Okay, so for a safe to be signed, Anya, you said that not possible in Serbia, and I'm actually these days talking to Silicon Gardens from Slovenia, from Plug and Play, VCs, and so on. They were in Belgrade, and we were talking about safes, okay? But just putting myself on the horizon there, but I want to be ready. I didn't know that I cannot actually sign it if I don't have LLC in USA. Or right? That's my first question, or at least in EU, Estonia. So I will let both of you answer if you can contribute to the.
Of course, yeah. So safes in Serbia are not recognized currently because of the legal system here. You cannot have a safe as you would in USA. You don't necessarily need to have an LLC in USA. You can have a C corp, or maybe one can provide more information on that if he's aware. But or in the EU, some countries also don't recognize it. I cannot provide. I mean, Estonia does. They have a really friendly startup ecosystem, but here that's not possible. What you can do here is have a convertible loan agreement or have a capital increase with some deferred valuation terms. So for the convertible loan agreement, that would be in a sense be a loan that's provided to the company now and then later converts into equity. The thing with the convertible loan is that you cannot have it automatically. So you cannot convert to equity automatically. You need to have a document. You need to submit it to the Serbian Business Registers Agency. It needs to be registered. It's a bit more, it's not complex because, the Business Registers Agency here it's a pretty straightforward procedure, but it cannot be done automatically. That's the whole thing. And the conversion can, of course, be triggered by any future event, financing rounds, valuation milestone. It can essentially be structured as a safe. It's just not a safe. It's a loan. And then you have a capital increase. That's where the parties agree that investors will receive equity with it when for example, a valuation happens. The mechanics are built in any corporate document, and then the structure, can be as you want it to be. In essence, the investor comes in the company, invests an X amount of money, and becomes a shareholder that way. Those are the two ways we see investors coming in companies in the region. What you should know when we're talking about the convertible loan agreement is that cross-border loans here need to be reported to the National Bank of Serbia, and that complicates the procedure because we have really strict forex rules. But other than that, there's no other legal obstacles to having such an agreement. Yeah.
Okay, so other than bureaucracy, it is everything can be defined as in a safe. It's just more bureaucratic way to do it here without a safe.
More or less, the safe is not. It's not a. It's
It's a
not
gentleman's agreement, yeah. And,
exactly.
that's
Yeah,
basic.
I mean, yeah, exactly. It's here you just have to have a bit more bureaucracy and it needs to be structured differently, but the effect would all in all be the same.
Okay. Juan Fernandez, feel free to chime in if you have something to add on this question, because I will move to next one.
Can I add, please? Actually ask.
On this question.
Yeah,
Yeah, please. Yeah.
thanks. So, safe cannot be done in Serbia. We can do it with a convertible loan. And convertible loan converts when we have next round of investment or valuation or whatever. If instead of convertible loan, we do equity in first stage with first investor instead of convertible loan, the only difference is that at the end of the day, he's all with next iteration of investment, the situation is the same. Like, I don't know if you can follow me, but in first round, you can either have equity or convertible loan. In second round, both will be equity. Right? Convertible loan transfers to equity, and you are practically on the same level. So,
Yes.
what would you say is important to look at when we are choosing if we will use a convertible loan or equity in the first round?
Honestly, that's more probably more of a commercial decision and what the investor's preference would be. So when you decide on what to do at an early stage, you need to see whether the company can be valued already today. If the valuation is sort of still uncertain and maybe difficult to support with concrete documents, a convertible loan will probably make more sense because it will delay the valuation until a later round when the company's traction will be at a higher level and the metrics will be much clearer. I don't know if that
So,
makes sense.
thank you so to clarify, investors saying, okay, we cannot valuate, we're doing convertible loan, I'm giving you X, and in next round, when we can valuate, we will see how much that X values, right?
Yes.
Okay, and if it's 100K at this stage and the next stage when we can do valuation, how you treat this 100K, because it's different than when it comes in second stage, someone with 100K, his 100K worth more because we're earlier.
So yeah, you in essence you are right. The 100K it will be treated as a convertible instrument until the next qualified financing round. At that point, instead of being repaid in cash, it converts into shares. But it does not convert at the same price as the new investors. Is that what you were asking? You would typically provide either a valuation
That's
cap
exactly.
or a discount for the new investor. Yeah.
And it's kind of an agreement between first investor and you. What's the discount rate?
Yes, exactly. The new investors coming in will probably request that they have, or the first investor actually is going to have a clause that says any more favorable terms that you provide to future investors, you also need to give me. And that's how they will protect themselves if you offer better terms to future investors. But other than that, yeah, it's as you said.
Thank you.
Okay, second
Okay,
question.
Georgia,
I
you
think those
had
are,
more
I think,
questions.
yeah, I had like four, I think, but all are topics that are relevant to all of us, I guess. Let's go through
Yeah.
them. Second was is the GDPR risk. Okay, so where is the boundary? Like, what is considered, if we are taking the keeping the data of our, users, like who must have it? Can anyone like launch a product without a SaaS product without, paying X amount of money for GDPR compliance? And what can we do by ourselves?
So I'm not a data protection specialist, so I cannot provide all information. All I can tell you, in a sense, is that if users do not clearly agree or we're not properly informed on the collection of data, then such collection would be, in a sense, unlawful. So those boxes that you tick when you go online to any sort of in Serbia, you're most likely to see those on newspapers and stuff like that. When you click yes, I accept everything here and my data being collected, that's what we're talking about when we're talking about being properly informed and clearly agreeing. You also cannot gather more information than you need to, because gathering more data, exposes you to penalties. That needs to have a reason behind your gathering. You also have to have data processing agreements. If you're, for example, you're controlling the data and you want to have a third party process such data, then you have to have a DPA, a data protection agreement between you and the person with who you're sharing your information. So, for example, if your company wants to outsource, have a platform where you will, put in all your holidays and stuff like that, like your leaves, etc. That platform and yourself need to have a data processing agreement so that the other party, storages the data in a certain way, does not mistreat them, does not transfer them to third parties and stuff like that. So it's really more of we would need to assess what you do and which sort of personal data you were collecting, and then provide a bit more information on how you can be protected. But yeah, use the minimum data necessary for your service, and be transparent about how it's stored and how it's used, and have clear privacy policies, and have cookie policies if you need them and stuff like that. That's the basic set of documents that you would need to be protected in the area of data usage.
And obviously it depends on your business and the sector you're operating in. So, I mean, at the end of the day, the data that you have is only for employees or from customers, so that's one scenario. So I think it's not difficult to comply with the minimum requirements. But I mean, if you move to the life science sector and you're having, for whatever reason, access to patients or, so that's becoming much more tricky. So, but I think that complying with this minimum and assuming that you are not holding this super specific data should not be, should not be super expensive. But I agree with you. I mean, the thing is that data protection is really so that all those penalties and the fines are huge. I mean, I recall we were selling in Spain manufacturing a chemistry, and so the outside lawyers they spot that one of the biggest risks was the data protection. So it was even more than environmental or any other thing, that was a manufacturing capacity. So just when you take this just in theory, and in some legislations like in Spain, the fines are huge. Yeah? So it's quite scary. I mean, then you need to really go to and see in practice, so how big is the risk. And in that case, that was a manufacturing capacity, so chemistry. So there was not a big issue from a data privacy standpoint, but still, so the lawyers believe that there was a big thing. Yeah?
Yeah, the whole thing with GDPR is that people don't usually consider if that they're providing their services in the EU. But if a person accesses your website and the website is in English and your products are in euros, then essentially you would be targeting EU customers. And that's something that people don't usually think about, because you're like, I don't have any customers in the EU. It doesn't matter that the authorities consider that you are targeting them, and therefore that the GDPR applies to you. So that's also something to consider when placing your product on the market.
Mm-hmm. Thanks. Next one, we are imagine a startup which is pre-money, okay, pre-revenue, and lawyer services, legal services are really expensive, like 150 to $200, euros an hour, more or less. So what are our options, what to offer to these expert lawyers, like you too, like your offices, like what are the options of collaboration there?
And if I just may add, so is there a are there packages for startups, for example?
Of course they are nice, really nice, expensive packages. I mean, what can be done without money, or with, like, can you offer something convertible loan, and what is a reasonable offer for you guys not to laugh when we come to a meeting? Okay.
Well, at least for us, like we love working with startups. We work with a lot of big corporations and a lot of huge companies who maybe in their heads were at some point startups. But when you work with some startups, you really see the people who are working really hard, love their product, and we really try to offer them the best possible prices, but prices that won't be charged immediately. Like with bootstrapping startups, we know that people cannot afford big law firms, right? So what we tend to do is either provide really good packages that can be paid after, for example, you receive a financing round, or something that blended rates, as one mentioned, like people, yeah, we would thank you for the love and support, but yeah, but yes, but sometimes, you can always talk to people and see based on their situation what would be acceptable to them. That's not something we wouldn't. Nobody reasonable would come and be like, "I'm going to charge you $200 an hour for a
Yeah.
startup." Those people either don't work with startups or don't want to work with startups because that's just not possible. So yeah, there are packages. You just really need to talk to lawyers because those who work with startups always have really good packages that they can offer you, or negotiate with you. After all, that can be acceptable too.
So you have a package that is like convertible loan at the first round of financing, you will get paid.
That's something that we have done in the past. That's with
Cool,
startups
cool.
that we work with. Yes, yes.
Nice, nice. Voislav, please, others chime
Uh,
in on the
Yes,
topic.
yes, I would like to add on this topic, especially regarding the lawyers. What George has said about the prices and stuff. Uh, I know that Karanovic law firm does not fit into a low-priced law firm, but actually a high-priced law firm. In that sense, for early stage startups, would you recommend to basically focus more on lawyers that are individual lawyers with expertise, or go more towards corporate large law firms like yours?
Honestly, diversify. That's what I would tell you. Diversify. You have a lot of individual lawyers who can do really, really, really an amazing job with certain stuff. And then when you're doing something, for example, cross border, when you're doing something with the EU, when you're doing something with USA, when you're doing something that is going to encompass multiple departments that need to work on it. For example, corporate, GDPR, regulatory. That's something that a big law firm can do really, really well, and something that maybe an individual lawyer cannot do so because they don't have the necessary expertise. So honestly, diversify. For anything that an individual lawyer can do, hire an individual lawyer. That's always a really good option. And for certain stuff that you wouldn't want to risk or would need more, specialized knowledge, then go to a big law firm, and those people will provide. We will provide, but no, yeah, those people will provide the best possible service for such jobs. That's my opinion.
I agree. It's a matter of cherry picking in the end. So, I mean, I believe that law has become a kind of a commodity in a sense. So there are things that, I mean, it doesn't make sense to spend a lot of money because, and you can use a single lawyer. And then when it comes to real important or real complex or more risky things, then you need to invest the money. So I think at least that you have the chance to speak with someone with experience, and they can tell you, okay, for this I will go in that way or in that direction, and for that I will go in the other direction. That's what I would do. So it's about cherry picking, yeah. And there's a lot of options there, and once you find the lawyer, so then as it was explained, so you can they will accommodate, yeah.
Okay.
Thank you.
Anybody else on this topic, or can we move forward?
Vojislav, jesi ti hteo nešto?
Not on this topic. I already mentioned I have other questions, but I just wanted to add on George's question.
Thank you. So next one, how can I validate sweat equity? Okay. So basically hours invested by people working on the product. Would they be like, imagine, I'm maybe imagining things here. Rolling safe, like, is that kind of thing exist? Am I inventing stuff here? Am I giving contribution to lawyer practice here? You get my idea. So how to validate that ongoing, I have an Excel sheet and I push people, this is not control. I want to acknowledge your work, okay? And we raised grant a smart start, and we spent it already almost. We have 1 month runway, but after that I want to, what can I offer to people who want to work with me without money, but I want to show them like my willingness to validate and acknowledge their efforts. Can we invent a rolling safe here or something like that? And should it be first like approved on the skupština, on the assembly of the LLC? I don't know.
Board.
Please, board. Yeah, who can answer this? Did you have this kind of question before?
Maybe yes,
Sweat.
this is something that, employee share option plans, or so they're called. So reserved option shares in Serbia, rezervisani sopstveni udo, I think is what you would translate it to, is something that can help. You would give in the future, after a certain vesting period, you would give such people a percent of the shares in the company. That's maybe something that you can say, I don't have anything currently, but if we work towards this, and if we build this startup, and if we get investments and stuff like that, I'm going to give you a 5% in 4 years if you complete these milestones. And that's something we see startups do with their with the person that they work with most closely.
How was the translation?
That's rezervisani sopstveni udo. That's essentially when the company takes its own share, but acquires a share from one of the shareholders, reserves it for another person in the future. It's basically a financial instrument. And then the person after a certain period would come and submit the documents and say, listen, here we go, I fulfilled all of these criteria. I can now, after 5 years, acquire 5% at a price that I paid for back in 2019. That's a really cool way to do it.
Thank you. That's an option, yeah.
But Georgia, just one thing for sweat equity, I think it is a different model. Sweat equity, you're giving advance for a services that you want someone to do in your company. For instance, you want an expert in marketing that has an agency, and you tell him, okay, you have an equity, you have sweat equity if you focus on my company. So you give him the sweat equity right away, and he does the marketing solely for you. So you don't have to give him that sweat equity later on. This, what Anya was saying, is reserved equity for employees that gets activated, for instance, after 2 years of work. But for sweat equity, I think that you agree, you make him a partner as a co-founder, just
as a co-founder, yeah.
For a specific thing.
It's kind of the same, I would say, right? The first that you said is giving it at the beginning, now making them co-founders, and the second one, I think it protects what Anya said, is more in the interest of startup. I don't know, maybe, after certain milestones are achieved, like I am, putting my blood, sweat, and tears into this, you put yours, and you could, be a millionaire in a couple of years or a decade. Okay, on this topic, thank you, Vojislav, for chiming in. Others on this topic, is it interesting to others? Maybe some other question related to this? I have two more.
I have something to add also on this. Sorry, Georgia, for
No,
bothering
sorry.
you.
Yeah, I like this kind of interactive approach.
I
Yeah,
have one question. It is also actually about equities. If an inventor of a product that is a holder of the IP that assigned the IP to the company has no operational influence on the company, but is an inventor of the product. What type of contracts in terms of royalties are suggested? Should that inventor have small equity in the company and still receive royalties, or is it a practice more for him to only have the royalties from the licensing or from a unit sold, and have no equity? So, what is? Do you have any familiarities in that kind of stuff when it comes to inventors with no operational activity? For both, question for both.
I mean, I believe that Anya has more expertise here, but I would go one way or another. So I saw cases where we need to pay royalties, and as the company grew and the product was super successful, this is really a burden. So it's not a good deal for the company. So I will try to make like a clean cut. So okay, they assign and you know, making them part of the risk by holding some shares. Obviously, those shares, as they are not the founders, so I mean, you can use different vesting periods and obviously and discuss on the amounts. But in my view, I would just stick it to only shares rather than having royalties. I mean, I don't think it's if the company is successful, the royalties is a bad deal really for the company. That's my experience.
But if the royalties are not large and are not really influencing a lot to the gross profit, let's say, I don't know, 5-10%
it's
of
always a
gross
burden.
profit.
I think it's always a burden because it will eat in any margin in the future. And investors would say you are eating into my margin, right? I don't like
But on the
this.
other hand, yeah, but on the other hand, if you give him equity, you're losing faster in losing the control of the company. So there is,
Fair point, yeah.
It depends.
if then but it is difficult to negotiate in that sense. For instance, okay, he doesn't receive the royalty, then he will ask for 30% of the company. But if he doesn't receive equity, he can get the royalties, but will have zero equity. So is it better to give 30% of the company or just give him royalties on products sold that are limited to some amounts?
But I mean, yeah, okay. Obviously, it depends on the amount of the equity that you want to give. But if this is really in the early stages, I don't think that you should give the 30%. And for me, one thing that it goes against the royalty is that when you want to bring an investor or when you want to sell the company, these type of agreements are really a pain, okay? Because you need to explain this, they need to understand. Maybe there is no chances to terminate that agreement because it was for a long-term royalty payment. So I think that's something that also it's a hurdle when you want to sell the company or bring new investors, because if the royalties are super profitable for this person, that will be an if, yeah.
But on the other hand, then if the patent can be sold, if the patent can be sold and he's the founder of the patent, but assigned it to the company, when it comes to the sales of the patent, if you sell a patent and he only has equity, a small equity, he's not going to be satisfied if he gets 5% from it because he has only 5% of equity. If he has a royalty, let's say of, I don't know, 20% of a patent sale, but no equity, then it is better for him. And in that sense, the company has no, let's say, the company receives the money, but has to pay the patent fee to the inventor. I don't know if I'm being clear. I'm just trying to find the best possible solution.
Yeah, but maybe that's a topic that you really need to start earlier, and I to identify where the IP will come from and get those assignments as soon as possible before that gets into something which is already a patent or becomes something that they can get royalties from. So that's the reason why having an IP, I mean, depending on your business, but having an IP expert from the very beginning and trying to get those rights assigned from the very beginning, it's a good option before they are bigger. And if this is in this early stage, I don't think that you need to contribute or give the 30% in return for of the company. So it could be a small amount.
The patent would be assigned to the company. That's not a problem. I'm just talking about the chunk of profit that the inventor gets.
I understand. Yeah, I mean, I don't know. I think we should look more carefully, but at least in my experience, I would rather go for for some equity rather than the royalty that is something that is staying there for a while. So it's quite a long time.
So for an investor perspective, you would say that it's better looking to have a bit messier cap table than to have royalties attached to the business.
That's my personal view.
Okay. Okay, I have two more questions. If the group agrees for me to ask them. Thank you. Okay, so what document, step-by-step guide, please? I don't want to prompt GPT. I can get answers from them, of course. But in your personal experience, what proved to be operational and practical, pragmatical way if we have a co-founder who learned what is a startup in the first year, and if they are living voluntarily? Asked, okay, of course, could you leave voluntarily, or if they're leaving involuntarily, what are the options in these two paths, and what are concrete steps that I could myself do, or any of us on the call? It's if a co-founder, I'm talking about a co-founder leaving voluntarily or involuntarily. That will happen in any point of time for sure for all of us. Just want to know in advance, please. What is your advice?
Maybe you want to take this over because that's usually found in shareholders' agreements for the good liver versus bad liver.
Yeah. I mean, so typically what happens is that if you need to define clearly, so what is with a bad liver? So if this person is breaching the whatever agreement you have in place, this person is really starting a new company, is competing, or so this, and in that case, this is related to what is he going to get, and that should be very clearly stated. So I believe that one of the rules is that he will just get. I mean, he will not get the vested shares, so he will get just essentially. So like
Nothing.
Was that?
Nothing.
I mean, obviously you can agree, but that's there are some standards. So obviously, if someone is leaving for illness or because there is no cause because he was, I mean, the other ones want to take him out. Yes, so he will get more than in the other case. But then, going into the specific amount is something you need to discuss. So obviously, in a good lever, he should be keeping the best in shares. That's my and with the value, with the current value, whereas a bad lever should get barely nothing or just face value. That's my yeah.
And what is just the notification over email? Here you are out of the company, or how do you do that in Serbia?
Well, obviously, there will be some formalities, and I mean, and I would assume that could end up in court if the amount is significant. So, in the end, you need to document all those things. But for me, what is clear is that at least is written very clear. So, if you leave for these X, Y, Z reasons, this is what you get, and if you leave for these other reasons, this is what you get. And if this is well documented and well explained, then I think you have a better case in court. And yeah, assuming there will be a court decision. Yeah.
Okay. Okay. Anybody else on this question?
Yeah. What you can also do is essentially, it would be just a contractual obligation. That's the bad news. Because contractual obligations end up in court. But what you can do is, if somebody, you would define what a good leaver is. That's a person who would leave, I don't know, because of illness or because of whatever other rational, reasonable reason it is. And the bad leaver would be a person who would, I don't know, terminate their working relationship unilaterally in a certain period, or
Yeah.
the company would terminate their working relationship for whatever reason, or they would I don't know, breach whatever clauses you would define in a shareholders agreement, such as non-solicitation and stuff like that. That person would be a bad leaver. And then the bad leaver, you can define it either way you want. You can define it as the bad leaver needs to, offer her share, whatever, to the other shareholders who will be staying and who will be entitled to purchase that share. And then you can prescribe that that share will be bought for €1. The purchase price will be €1. Versus if a good leaver leaves, then you would, purchase their share for market value, or for whatever, valuation at that point is for the share. You can do that. You can just say, I'm going to purchase your share for €1 versus I'm going to purchase your share for what it's actually worth. And that can be the difference. And you cannot just, say you're leaving by email. You would need to actually, make them transfer the share to you, which in Serbia means have an agreement and submit that agreement to the registry, and then that's processed, and then the share is transferred. So again, it's a contractual obligation. That's what I said at the beginning.
Yeah.
Whether or not they're gonna actually sell the share to you for €1 and accept to sign that, is is a different topic.
It's up
But
to
I
me,
think
yeah.
that's
Okay.
Yeah.
Okay, and the last one is how to separate responsibilities for services versus products. So imagine you are building a product with some people, okay, but is it smarter to like establish a new entity, legal entity, and deal with services in the same domain of software development, let's say, whatever, or single entity could be kept. How to separate responsibilities between co-founders, or CEO and other co-founders and so on.
But I mean, again, this is something you need to address in a contract, and the contract will be between the company and the specific employees or third parties. Okay. And when it comes to services, I think it's very clear. I think it's more or less a contractual. You can say, so what is the type of liability? But when it comes to products, and again, I go back to the example of medicines or other cases where it's related to product liability is defined by law. So no matter what you agree between the parties, in the end, there could be a certain penalty, and you cannot escape this penalty. Okay. So I think it has to do with what you regulate in contract, and there are things that you cannot overrule or regulate in a different way in the contract, even between the parties, because the moment you have a third party, they will say, okay, I'm not bound by this contract, and this is a health authority or this is another authority, they will go against the responsible no matter what you agree on the contract. So I don't know if I made myself clear.
Yeah, can it be part of a shareholders agreement in some sort as an appendix or something? I don't know.
But you want to keep one of the founders not liable for product liability? Is it what
and
you're
also
saying?
not entitled for the benefits or profits from coming from services, for example, because they are not contributing to services and other, stuff. So in that sense, how to separate that also liabilities, but also entitlements, benefits from other.
But that's another thing. So in terms of benefits, I mean, I don't know if in Serbia you can do it, but there is some tracking dividends in some jurisdictions, so that you can say you have some shares, and these shares entitle you to receive the dividends or the benefit of this, let's say, business unit. So that's something you
Okay,
can do.
that's
So,
cool.
but that's you can use different type of shares. So you say, okay, so shares type A allow you to receive dividends from this business, and type B from that other one. So that's something that you can address. But this is only on the benefit side. When it comes to liabilities, I think it's completely different, because in the end, it's not the liability of the founders. I mean, obviously, if you as a shareholder, you don't have any liability. You have a liability if you are a board member. So as a board member, you will be you can be held liable for civil, criminal, environmental. I mean, at least in most of the European jurisdiction. But that's one thing. But still, this is something that is difficult, because in the end, I mean, there's some procedures to get the liability of a board member. Okay, so it's not that. And on the other side, if you are thinking about contracts with third party, the counterparty to the contracts will be the company, not the shareholders. So is company A is contracting with a third party services, or is selling products to another one, and that contract will regulate the different liabilities.
On the benefits, so also the board member can be excluded from certain benefits if they are not contributing to a certain business unit.
Well, but that's a different thing, because the board members, I mean, as a board members, but it's not typical I mean, some board members are not paid, but typically you need to treat all of them in the same way. So you can say, okay, so being a board member is remunerated and you get paid this amount plus this amount for every meeting that we have. But the moment you decide that being a board member is for free, it has to be for free for everyone. So you cannot have board members getting paid and board members not getting paid. Okay, and that's the fact of being board member. So what you get as a shareholder is completely different. It's because you put money and there is some benefits, and as a result, at the end of the year, you get the dividends. But this is a shareholder, not as a board member.
Clear. I don't still know what to do with board members who are not contributing to a certain business unit. That would be an open question for us to maybe follow up. Thank you, guys. These are all the questions from my side. I'm happy to
Okay,
hear
now
questions.
because I saw that I saw which one of you has which question. So Voislav, would you like to continue because you also had specific questions?
Yes, sure.
Yes, sure.
How can a founder be protected from dilution in cases when the revenues are not, for instance, is there some limit that can be contractually made so that there is a minimum dilution that can be done? For instance, it cannot go below 5%, let's say, as an example.
If they're not reaching milestones, that's what we want from investors, right?
Yeah, because in that case, for instance, there are cases where investors or VC they're raising money because they need capital. They're also going to the founder and asking the founder to invest as well, so that they raise certain pool of money. Is there a way for a founder to protect his equity without investing, or any other instrument that can protect complete dilution of the founder's equity?
I don't know, Anya, if you want to start. I mean, in my view, so the way to protect is that when you raise capital, and this is either amongst the existing shareholders or because there is a third party, you have this first of right. I don't exactly know the name, but is you have the right to subscribe the proportion in capital increase as the same or comparable with you hold. So meaning that when the capital has been increased, you still have the same percentage as you have prior to the increase. So that's the way it works. But I mean, obviously, I mean, you need to have the power and to go for that capital increase. So if you want to bring a third party venture capital or whatever, and they are willing to put significant amount of money, obviously you will be diluted. So for me, it's a matter of it's a contractual deal. But at the end of the day, I only know this way to do it. So the moment that you increase the capital, you proportionally subscribe an amount that will keep you in the same level of the share capital as you had prior prior to the capital raise. I don't know.
Yeah, that's also what I wanted to say. I think it's a thing of a contractual negotiations, but you can. But I understand that you mentioned that you would not want to subscribe essentially the same. You can do a pro rata, right? Like you can just have the right to essentially, if an investor invests an X amount and receives an X amount of shares, you have a right to invest the same amount so that you would not be diluted. But if you would not want to do that, then you probably could add a clause that would say that you would not be diluted. But I don't know which investor would accept that. That's the whole thing. Yeah, it's a contractual thing, I suppose.
Yeah, or as an alternative, you can get the money via loan or via obligations. So if you issue obligations instead of shares, so that it doesn't change your position as a shareholder. But I mean, I don't think this is quite usual in small companies to issue obligations. So I wouldn't say, yeah.
Okay. Thanks.
Boys, do you have any more questions?
No, this is fine.
Okay, then let's go to Tatiana. If she's here. Tatiana?
Yes, I'm here. I'm just trying to remember. I had millions of questions, but I wrote down just several of them. But
Yeah, so let's start with those. So maybe that will kickstart the memory for other questions.
I remember the one question is about, for example, I register my company in Serbia, but I work for European auditory and another thing, like I'm making a marketplace with companies in the third countries in Africa and Argentina, actually around the world. So what law I should follow? That's actually a question.
So what is your company about? So what are you selling or
It's
services?
the responsible travel marketplace. It's volunteering internships. So most of them, they're in Africa and in Asia. But target audience, it's European, it's Germany, the UK, and France for the beginning.
Probably then, Serbian laws, because your company is in Serbia. So for matters such as corporate governance, shareholder rights, stuff like that, you would follow Serbian law. Taxes to pay here, you would follow Serbian laws. But then you should consider, if you have customers in the EU, you should consider customer protection
GDPR.
laws. Yeah, in the EU,
Mhm.
then data protection laws, as we mentioned, GDPR for sure. I don't know. I don't know if there are any sector specific laws in the EU for that, but probably those as well.
Mhm.
And let me see if I can think of anything else.
I'm just worried that's like I will run the business from Serbia, but there could be some specific law in South Africa, for example. And I didn't know about that, and I end up in trouble. But I cannot just check every country where I operate. It's a little bit complicated.
I'm actually not sure. I cannot provide a more concrete answer than that. I'm sorry, but it really depends on which sort of laws do you think that you should be following with regards to those third countries, for example. What sort of things do you do there?
It could be actually what first come to my mind. It's about labor law because it's volunteering, so it's probably somehow connected. But as a marketplace, so I'm mediator, like should I do that or not? So it's like a kind of specific questions about marketplaces. I think like every marketplace has this issue. But yeah, I just wanted to.
Is there any chances to contract using your company? So meaning that there will be transactions, or people, in the case you mentioned that in Africa they would be paying via your webpage or something like this?
Yeah, they like program providers. They list their programs
Yeah,
and there are users who will pay for these services, like to participate in this program. And we
yeah,
take a just percentage. It's like commission based.
yeah. Yeah, I mean, obviously, so to the extent there is some advertising, that's something you need to check because, I mean, it has to be, I mean, there's some rules governing always the advertising, and we are addressing this to customers, to the public in general, no? So that's one thing. It's not just professionals. And then, obviously, so if you're collecting data again, so GDP from those customers, I mean, I'm not sure if labor is something that would apply because I think it's more like a contractual thing. But to the extent that there are some payments via the web, I think that you need to double check locally as well if this is something that can be done or not. Yeah, but that's just a bit
So does
rule
the
of thumb. Yeah.
Serbian company employ the people who work there? I'm sorry if I missed that, if you mentioned it already.
We could consider that, but it's not our initial plan.
Okay, yeah,
It,
that's
it could work, but we'll think about this later.
okay.
And another question, what I see, I don't know, maybe it's Googleable and I'm just lazy and didn't check that, but it's about registering like intellectual property. Where should I do this? Like, for example, I can register my trademark in Serbia. Would it work in the UK? Or like, is there like some, I don't know, office where I can just register that and it will work for the rest of the world? How does it work?
Yeah, exactly as you mentioned that you can register it here for Serbia and for the UK. But if you registered it for Serbia, it will not apply to the UK. That's the whole point. But you can do everything in Serbia now. That's the good news. You can just go to the IPO office here, and then it's a fairly simple process. And the IPO website has really clear information. It's actually one of the best websites of a public authority here in Serbia. It actually has really good explanations. You can do everything by yourself. You don't even need to hire anyone to do that. It's a pretty simple application. You select for which countries you would want your trademark to apply to, and then those countries in those countries people could not use your trademark. That's the whole thing.
Okay, that sounds promising, actually.
Yeah, it's just a national registration versus an international registration, and it's like for the EU, you could just do EU, and then you will be protected in the EU, if I'm not mistaken. But I think so, yes. And then you have 4 or 5 countries that are not in the EU but are in Europe that you can do those together as well. It's pretty simple to do. It's really
Mm-hmm.
it's really good, and it will last for 10 years, and that's great.
Okay, thank you so much. Maria, you want to
May
add
I ask,
something? Yeah.
related to this? So, you're kind of a registering IP over some logo or whatever name in Serbia. But if you have IP, like a methodology, like some knowledge or whatever, and you want to register that, are you doing it on a personal level, like specific person who is a co-founder, or on company level?
I'm just unsure what IP you're referring to.
Intellectual property of a methodology that company is using, or yeah, that's the best description. We use specific methodology that we developed over time, and this is our mod for the startup. Are we protecting it as person who actually worked on it, who created it, or it's something registered for the company as such?
I actually am not sure whether methodologies fall under copyrights. If they do, then you would not need to register anything. But I can maybe I can check it real quickly.
I, I didn't expect it as a copyright, but I thought that there is something different that can provide some sort of like Montessori methodology, let's say like
Okay,
that. Is
maybe
it
I'm completely,
connected?
I
Yeah, I'm
believe
not.
that in Serbia, sorry to interrupt, I believe that in Serbia you cannot register methodology as an official methodology. It has to be an author's work, I believe.
Yes, I'm not sure. I'm not really sure. I'm not convinced that it's copyright, but I'm also not sure that I don't think that you can register it as such. I think that it would more, fall as business, as trade secret or something like that. But I'm sorry, I'm really not an IP specialist, so I can't answer this precisely. Yeah, sorry. But I'm pretty sure that it's not, you don't have to register it. That's the whole thing. The thing with those such IP rights is that the person who created them, it wouldn't be the company. I'm sorry. I really don't know, so I wouldn't want to give you
Okay,
a wrong
totally
answer.
fine.
Yeah, apologies.
If you're thinking about know-how, you cannot protect it as it is.
Yeah.
You just
No,
can,
it's
make
methodology.
money from
Yeah.
methodology as described. Methodology on paper is a copyright because it's described on paper. But copyright is automatic right. So yeah,
Mm-hmm.
so there are no cost of protection.
Okay, thanks.
That's all from my side.
Okay, Maria, do you have anything else?
On this topic, no. Let me see. What were my questions here? 1 second. The questions.
Tamara, could you just repeat which rights don't have a cost of protecting?
Copyrights. So
Copyrights.
if I sit and write my methodology on paper, that's my knowledge, and but I'm still confused how Montessori methodology is used by different kindergartens all over the world by some specific rules, and how that's protected. How is it protected, or it's just
How franchise,
not just franchise, but it's like a methodology that gives you very clear definition how personnel in kindergarten or teachers or whoever needs to behave, and what are the activities for the kids and so on. And I'm just thinking, and they need to have some checkups regularly if they're still following the rules of methodology in order to be named Montessori kindergarten.
So you should look up into it, but probably by your description, it is a franchise. And because of the brand name Montessori that goes with it, that it's probably, they have a trademark and recognition, wide recognition. So that's go, everything in the package with the methodology.
Okay, got it.
Yeah.
Okay, I wanted to ask about term sheet. So term sheet, if I understood correctly, comes before the agreement, the shareholder agreement, when it comes to investment. And it's like a secret document, whatever we agree with be put in term sheet, la la la. But I wanted to ask, are there any good practices that you are advising what to put? I saw what ChatGPT is giving, but anything related to term sheet, how important it is? Is it really so important and prerequisite for shareholder agreement, or at the end of the day everything is in shareholder agreement and term sheet is just a gentleman's agreement that we will do the shareholder agreement?
I mean, I can start. So the term sheets, it's a way to avoid discussions when you discuss and negotiate the shareholders agreement. So I think it's like is the idea is to put together in a document which typically it's non-binding. Okay, so what are the key terms and conditions that you expect to see in the shareholders agreements? Because if you start drafting a shareholders agreement from the scratch, so you might be aiming in one direction and the other shareholders or the investors will be aiming at other direction completely different. So it's a way to saying, okay, so how do we want to approach these different things? Okay, will there be this tag along, drag along? Will there be these good levers and bad levers? So how do we, want to raise funds? All these type of things. So the idea is to put this in the term sheet in order to have at least understanding on the main terms and conditions. Okay, but then you need to go to the second phase, which is okay, now go and fine tune the shareholders agreement with all the wording and with all the length of the shareholders agreement. Okay. So I think, I mean, some people want to start directly with a shareholders agreement. I recommend to start at least with some skeleton or some term sheet, because in the end, you see what is the alignment in the main terms and conditions. And obviously you can refer by wording standard to other provisions that typically come in a shareholders agreement. But I think it's a way to be more efficient. So confidential, yes, you can say that obviously, so the discussion of the term sheet and the negotiation will be under confidentiality. You can also agree if there will be any type of exclusivity while discussing with the shareholders, with this investor. So these things you can also include it. But in the end, the term sheet per se is not binding. It is not binding because it's not precise, it's not accurate enough to be a binding obligation, and is just meant for discussion and further negotiation. Okay, so I would say yes, confidential, in principle not binding, because if it would be binding, you just don't need the shareholders. But some of those term sheets are quite elaborated, but still you need to, I mean, not everything is included there. That's the idea. But it will save you time and it will save you some useless discussions, because if we agree what was in the term sheet, then the question is how we draft it afterwards.
So the drafting is with lawyers, and term sheets are something that we can do without lawyers. Like
Well, I would use the lawyers for both things, because in the end, I mean, a lawyer will tell you what to be included in the term sheet, and then maybe you are including things in the term sheet that then you are kind of forced to include afterwards in the shareholders agreement. Yeah, or I mean, not because it's not binding, but then when you start discussing, I mean, there was one recurrent argument that you can find from one party saying, okay, we agreed on the term sheet that this will be one of the sections, and now you say no. Okay, so that's in order to avoid this kind of embarrassing situation that you don't want to include things in the shareholders that are in the term sheet. I think it's better go with a lawyer from the beginning.
Got it. Thanks. And a very concrete thing, my startup is related to a lot of data related to kids. So parents subscribe their children on our monthly service and on monthly basis, they provide feedback about how their kid reacted to the book that we send, and are there any new phases and new interests that kid is showing. Should I ask for acceptance of terms and conditions or whatever GDPR related data every time that they're providing new information about their kid, because it's on monthly level, or it's enough when they're on board?
I'm not sure here. I'm not a GDP expert, so, but I mean, I will be careful with this. I mean, with kids and all this personal data, I will be conservative. Yeah, but I mean, I think you need to check with an expert.
Okay.
Yeah.
Thanks.
Okay, who's next? Marco?
Hi. So thank you all. Voislav and Georgia already, let's say, posed several questions, as well as Tatiana, that I also had. Let's say, not to repeat, I would just pose this one that is out of the previous discussions. So, what to do if with the company is doing, let's say, a certain job let's say, different jobs for another company, and that other company is also investor in one product of our company. Okay, so we have, let's say, agreement signed. Okay, then there was annex of agreement that was, let's say, a little less favorable than the initial agreement that was signed by the official from our company. So we would like then we will of course have the other contracts coming soon. So if we come back to the let's say to the first type of contract that was also agreed with this third type of contract, then this second type of contract that is a little less favorable than the first contract is then the third contract is valid, right?
I'm sorry, can you just is the third contract is the last one that's signed?
It will be the last one that will be signed, yes.
And the question only relates to which contract would essentially apply.
Yes.
That's the latest one, the one that you signed, the latest one will apply for sure. It doesn't matter which, essentially with every new contract. I mean, it depends whether is the contract the same as the previous one. Is it essentially annexes? Is that what you mentioned?
Yes, there will be, let's say, there will be annexes.
Mm-hmm. Yep. Then and they will govern the same things that are governed by the previous one.
Yes, it will relate to the part of the work that we're doing for them, but also to the work that they're investing in our product as well.
The last one will override any previous. That's most likely how the courts would see it. Is the last one would be the one that's unless you. I mean, the great thing that you can do is just say if you want the previous one to apply, then just put a sentence in the contract saying, with regards to this and this, the agreement from and then date applies if there are any discrepancies between this agreement and the previous one. That's something that you can do to, sort of bind them together and say everything else in the agreement, this agreement shall apply to everything else, and the other agreement, the previous agreement, shall apply with respect to this certain clause, whatever you want to add. That's something that you can do if you want the previous one to apply, if this one will have less favorable terms, if the other party wants to agree to something like that. But otherwise, probably the last contract that you sign would be the one that the courts would say is your latest will, sorry to say, your latest something you agree to at the latest. Yeah.
I think a good practice is, so whenever you make significant amendments to an existing agreement, is that in the recitals in the beginning, so you refer to the previous agreements, and then make sure that you say that this is an amendment, a restated agreement, so meaning that supersedes and replaces the previous one, and you don't have any question whether is there any provision of the first one that is still alive or not. So it's like making a consolidated version of those agreements, because otherwise you will end up with pieces of different agreements. So okay, so the initial one was governing X, Y, Z, and then we make an amendment on the term on the products, but then we make another one, and in the end it's a completely mess. So I think it's better if you're doing significant. I mean, obviously, if you just make a small amendment because you are updating the products, the list of the prices or whatever, you don't need to amend the whole thing. So it's just, okay, so this is the annex and replaces the annex of the previous one. So those things that you will see that they might change during the term of a contract, is good to put them in an annex, okay? Because it's just amending the annex and then that's it. And you don't need to revisit all the content with the counterparty. But I think, yeah, so good practice is stating that this is a restated of the agreement and it's like the consolidated version.
For sure. If you have a lot of amendments, just have a completely new agreement, and you will say exactly this one mentioned. If you only have one clause that you need to change or want to keep or whatever, then just say annex and then this clause is being changed, and then refer to the clause and leave everything else untouched. If you want to, leave only one thing from the previous contract, then just have a whole new, he's completely right.
Yeah.
Just have a whole new agreement and say that everything you've done so far doesn't apply anymore, and this agreement is the only agreement in force, and that's it.
Yeah. So if the amendment you're doing is small, making sure that you say that the rest of the terms of the main agreement remain unchanged, and that's the only change in the new agreement, and then this is very clear because you take both and you see, okay, this is what is new, but the rest applies.
Thank you both for this. So this was my, let's say, new question. Other questions were already, let's say, posed by George, Voya, and Tatiana. I didn't have overlapping with Maria.
Okay, thank you. Anyone else? Alex, Andrea?
No, all good from this side.
Just a second. Yeah, I have one question regarding my product. It is some kind of platform where different people will meet each other and in professional sphere, and will give some kind of advice, recommendations, business wise, etc. How to protect myself, my company, my platform from abuse, bad advices, etc. Because it will be happening on my platform, although I cannot guarantee correctness of all information that there will be brought, if you get me.
If I understand correctly, then you can probably have terms of use of the platform, and then if anybody doesn't follow the rules, you can exclude them. If they're going to be having accounts, then remove their account, block their account, something like that. Is that something that you were referring to? Is that something that could?
Well, yeah, it is one part. It is easier part. But on the other side, when we talk and you tell me something that it turns wrong or that I don't like, then I can say you told me here and you were wrong in the scope of FI cohort, if you get me. So it
Do you think
doesn't
like
have to
having a
be
waiver?
really. Sorry.
Do you think like having a waiver, not being responsible because you're just a marketplace, not being responsible for acting, or what comes from interaction of the parties?
Yeah, what comes from interaction from parties, yeah.
So do you want to add something, mentors?
One,
I think that,
yeah.
Yeah, Anya, please.
No, I'm really not sure. Do you want to protect yourself from any bad advice that somebody gives other people?
Yeah.
I mean, it's like building a social network. I mean, how Facebook, others, people can interact to do whatever they want. I think it's maybe under terms and conditions what I said to you.
Yes, terms and conditions of the platform, you're essentially only connecting people. So I'm trying to just think how you would even be liable in such a situation if a third person gives another person bad advice. I'm not sure. I mean, I'm sure, of course, sure that somebody can always say, yeah, you're at fault, just like they say for TikTok and Facebook and everybody, they're at fault for, people posting stuff and other people seeing it. But I'm just trying to, again, I'm really not completely sure, but probably having this in the terms and conditions of platform use, explicitly saying that, people should be careful about the advice that they receive, and that you are not the person providing the advice, you're only the facilitator. I don't see how otherwise you can do that, except also telling people who will be providing the advice they should mention, you also telling them that you will not be, that they're providing advice at their own account, and that you're essentially only a facilitator. I'm not sure. Maybe it has something to do with also that's the best that I can say, only having terms and conditions that's clearly state this on
Thank
the
you.
web.
Thank you.
Easily accessible, of course, that people can see, easily popping up and stuff like that.
Sure. Yeah, I have already. Yeah. Thank you.
I don't know, Juan, if you have anything to add, maybe from your experience.
No, I agree. I mean, it's about the terms and conditions. I don't know if we can control more. Yeah. And write disclaimers as well. Yeah.
I have a question, if you have time. It's an interesting one.
Okay, yes. Okay, let's hear it.
So most of us, I guess, are envisioning putting themselves on the VC track. So what happens? Can you elaborate a bit? Were you involved in the cases where a down round happened, lower valuation in the next round, when full ratchet kicked in, a clause diluting, by a huge amount the stake of a founder, and protecting the investor? Of course, they get like proportionate shares without losing the value. But have you ever dealt with that clause full ratchet? I saw it somewhere online and found to be quite an interesting one in the down round. Can we protect ourselves from that, or just don't sign it if we see it? It's like, when the next round you are valued lower than in the previous round for whatever reason.
I personally haven't had that situation happen, but when you say full ratchet, you're probably you mean that if, for example, an investor buys at 10 million and then the next round
Valued
happens
at 7, yeah.
yeah, whatever, and then happens at the lower amount, then this clause would essentially allow that their earlier investment is replaced as if it was invested at the lower amount, right?
Yeah, they keep the value of investment. They get more shares at that lower value, and they are safe. But like co-founders, founders' stake is diluted. So this
You
okay
cannot. I had that situation.
Okay, and what
There's
happened?
nothing you can do. There's nothing you can do.
So you
Yeah,
had that
thank you.
situation,
I
but
had that situation. There's nothing you can do.
but you cannot. You can say, I don't want. I want to. I want
They
to
give
sign.
you. They
Yeah,
no. They offer you a
yeah,
package
yeah.
that is not going to be very favorable, or you get diluted to the max.
Okay. But what was the name of the
You don't.
clause? Why?
Well, the thing with that is that whatever the clause or whatever the circumstance that you have with the VC fund, you're in a bad position if the company is in a bad position.
Yeah.
If the company is in a bad position, the VC fund is going to take everything. Simple as that. And if you want to battle with them, they're gonna kill you with expenses, with lawyers and stuff. So that is a battle you're losing. So your only chance in this aspect
Not to
is
take
that
money.
your company is no, that your company is profitable, that you have
Yeah.
good projections.
Yeah.
So the success only guarantees success.
Yeah, clear. Okay.
Then also maybe, try to negotiate an anti-dilution or a cap or something for dilution if you
No
can.
way. They're not
Yeah,
gonna
no way.
let you in.
Yeah,
Nothing.
try. You can always try.
Yeah, you can try. I mean, you can
Yeah.
negotiate.
You can try and you will. You can try and you will.
You will fail, but you can try.
You can try and you will fail. Yeah. So the
Yeah.
only
But you will feel better
only solution.
if you try. Yeah.
I had that situation. My previous company was valued at 10 million, and then the how did you say, downgrade to
Down round. What's happened?
down round? Sorry, down round happened to 3 million.
Damn. Were you evaluated? Valuation happened in USA first?
Yeah,
First?
USA.
Yeah. So that's just for everybody on the call. That's the risk of like,
It is a very big
I
risk.
want to get a higher valuation the first round, so their
Don't
investment is like
don't.
lower stake. No, like that's a risk, yeah.
A lower valuation and
As far as possible in the
the
pipeline.
the longer you survive without VCs, with success, the better off you are. So going just for the money without having a business that you're let's say serious about in long term, not serious about it, but you're sure that the success rate is going to be in the long run, you are just getting the money that will be potentially burned very quickly, and you will get stuck with investors that are going to take everything from you if you do not justify that within a year or two with results and profit.
Thank you all for the attention on this call. It was amazing, Anya and Juan and others.
Juan, Antonio, maybe you have to add something, about George's question about dilution.
I was not in that case, sorry, so cannot be of help. Sorry.
No, thank you all so much. This was really like intensive discussion, a lot of good questions and great feedback. So Anya, Juan, thank you so much
Pleasure,
for supporting us. Yeah, this was a really interesting session. And founders, you will have the recording. If you didn't catch everything, all the feedback that our mentors gave you, you can watch the recording. So thank you. If you have any, space for office hours, both of you this year or the next, it would be great if you can put some office hours for our founders. So everyone work on your assignments, be prepared for the next session. You will get invitation for a meetup on 15th of December. So it will be a combination of entrepreneurial quiz with pitching. So it will be a great opportunity for you to hear what other startups from the ecosystem have achieved and to participate in one startup quiz. So I wish you all great rest of the day, if there is a rest of the day. Hopefully you do not have to work until midnight, and see you next week. So
all the best.
bye-bye.
Have a great day.
Thank you. Bye-bye.
Thank you.
Bye.
Ciao.
Thank you. Bye bye.
Likewise.